Stephen Gold.
Have you written anything?
Well, I put an X on that ballot paper the other week, and there's that book.
The Return of Breaking Law.
Well, I didn't like to say.
Don't start trying to flog it again. We all know it's marvellous. You had great reviews from Jon Snow, Piers Morgan,
Anna Botting, Fred Dinage, Professor Dominic Reagan, Daniel Barrett, Nigel Pascoe, King's Counsel.
I'm going to get on with some
Justin
juicy
Webb,
law. After
Peter
all,
Johnson.
this isn't Waterstones.
It's legal. It's legal.
Firing and rehiring. That's the trick sometimes played by an employer who wants to change an employee's contract for whatever reason, usually to save themselves some money. It may lead to an unfair dismissal claim if the employee refuses to have new terms stuffed down their throat, especially if there's no clause in the employee's contract which allows changes to be unilaterally imposed. Or it may not. The new government is to outlaw firing and rehiring. For the time being, though, a code of practice on the subject to be followed by both sides came into force on the 18th of July, which they must abide by. Well, what sort of things does the code say? Information must be provided to the employee about what is behind the quest to change the contract, business reasons, other options considered, proposed next steps, that sort of stuff. There must be good faith consultation with the workforce, though. If the business is suffering a financial crisis necessitating a shorter consultation process, then the code accepts it may not be able to provide as much information as a business in more settled times. And if the employer fails to keep to the code and there's later an employment tribunal claim by the employee, for example for unfair dismissal, any breach of the code can be taken into account by the tribunal. And a failure by the employer to have followed the code could increase the employee's compensation by up to 25%. Conversely, a failure by the employee to have followed it could reduce their compensation for up to 25%. The employer should make contact with ACAS for advice before raising the prospect of a fire and rehire, and is open to the employee to themselves get advice from ACAS. You name it, and you probably won't be able to get legal aid for it. That's a lawyer to act for you in a civil or family case, to bring it or defend it, to give you all the legal advice you need, deal with the paperwork, speak for you in court, paid for by the state with a possible financial contribution from you, depending on means. You may be able to source free advice and other help from a variety of sources, but there's a heavy demand on them, and it's not the same as the real full deal that comes with legal aid.
What sort of cases are excluded from this full legal aid scheme then?
Well, consumer and breach of contract cases, generally accident claims, family law cases such as financial applications on divorce, disputes over children, except where strict criteria are met regarding domestic or child abuse.
But what's this about legal aid you thought you couldn't get? Are you hiding something up your sleeve?
Well, apart from my arm, you mean? What I'm on about is the exceptional funding scheme. It can be taken advantage of where you financially qualify for full legal aid, but full legal aid is not usually available for that type of case, as in those examples I have just given. But to get this exceptional legal aid, you must show that a denial of it would amount to a breach of your human rights. Let's say you would effectively be prevented from presenting your case, maybe because English is your only secondary language, you're slow on the uptake, you can't read or write, you've no friend who can help you, and the case is complicated with loads of documents which are completely beyond you. All these factors would obviously put you in a bit of a mess, and you wouldn't really need them all, but combined they could certainly secure you exceptional funding. Be warned, though, this exceptional funding is difficult to obtain.
How difficult, Stephen?
Well, let me take you to the figures just disclose. In the first 3 months of this year, there were only 910 applications made for exceptional funding in the whole of England and Wales.
Why so few?
Well, I reckon it's because the scheme isn't sufficiently well known, and, of course, the criteria on the merits for getting it are so limited and strict. But of those 910 applications, 77% were granted, they were successful. Top of the category of case for the successes were immigration, followed by inquests, and then family cases. You can apply for exceptional funding yourself. For forms and guidance, go to this website. Or better still, try and get an appointment with a law centre which can use their expertise to help you. Or
Here it comes.
get my book.
It's legal. It's legal.
If you had an accident which has caused you personal injury for which someone else was to blame, and you could claim for compensation for injury, you can add in other things: loss of earnings, the cost of medicines, value of your ripped jeans and bent nose ring. On top, you can claim interest on the compensation. And when it comes to interest on those other things, interest, which could be substantial, bearing in mind that you could be waiting for a couple of years at least to get a settlement, will be based on what is called the Court Funds Office special account rate, and that goes up and down like a yo-yo. It's gone down by 0.75% from 6% to 5.25%. The change was effective as from the 12th of June 2024, although that was only made public on the 18th of July. The interest is calculated on the losses at the different rates that have applied for the different periods that have elapsed since the accident. And if that is not something that will induce your calculator to break down weeping, nothing will. You see, since June 2020, there have been no less than 11 rate changes. You'll see them in a mo. Incidentally, if the Court Funds Office is holding money for you, and this may be because you've had an accident when under 18 and you're not allowed to touch the money except in special circumstances until you reach 18, this latest change will affect the amount of interest being earned on your money. The special account rate will probably apply. If not, the basic account rate will apply, which has also gone down to 3.94%. Well, if you think you can do better with an investment in your own account with a building society or bank, unlikely with the special account rate, you can always ask the court to allow you to transfer your money over to an outside account. If still under 18, that application would need to be made by your litigation friend, the adult, perhaps a parent, who made the original claim on your behalf. We've had mediation coming out of our ears recently. How those involved in civil and family cases are being encouraged. We have ways of making you mediate, to settle their differences through out-of-court mediation or some other form of dispute resolution, rather than have the case tried by a judge. In theory, quicker, less paraphernalia, cheaper, and helps to clear the backlog of cases that have not settled and which the judges can't avoid hearing. Well, in county court small claims, we now have what's called compulsory mediation, which is no such thing really, as the only sanction for not cooperating relates to costs. And it's a cost sanction that can now be imposed in family cases where one party unreasonably refuses to try and settle out of court. But in civil cases, an unreasonable refusal could ultimately lead to your claim being thrown out or judgment given against you. Of course, there could be a mountain of good reasons for a refusal, especially in family cases where you may be terrified to have anything to do with the opposite party out of a court setting. What is important is that if you have a good reason, whatever the kind of case, you communicate it to the other side or the court. And in a case just before the Court of Appeal, it was ruled that where the other party invited you to mediate, you could be sanctioned by staying SHTUM, not responding, even if you had a good reason for not going along with the suggestion.
They think it's all over. It is now.